Welcome to Kent Academic Exchange. I am Benga Odunton. I would like to talk about the recent judgment given by the International Court of Justice just in the last few hours in the case application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip. The Court of Justice, the International Court of Justice, has given a decision, and in this short video I hope to talk about what the decision is. I will talk about the conclusions and measures to be adopted, and I will talk about I'll try to place things in context of international law and international relations. I'll be making references to a book I wrote way back in 1999 on the International Court of Justice, and I'll also be supporting my analysis with extracts from a book written by the Council for Israel, Malcom Shaw. Malcom Shaw is representing Israel in this case, and we will be taking some extracts from his work as well. And let's get straight to work. What has the court done? The court has done a lot, and I suggest that South Africa has gotten between 70 to 90% of what it needs in the judgment of this court. I have absolutely no doubt that this is a win for South Africa. You rarely ever get 100% victory in any court case, but even more so in international relations. Let's go on. What did the court say? Conclusions and measures to be adopted. You will find this in section 7, paragraph 75 to 86 of the judgment of the court on this issue of preliminary interim measures. Let's get it straight once and for all. What the court is doing right now is not deciding on the full merits of the case. What the court is doing is deciding on the application for preliminary measures. The request for the indication of preliminary and provisional measures requested by South Africa to arrest the situation in such a way that it doesn't prejudice the case as it goes along. But it's a very important part of this case, given the nature of the events going on in Israel. So first and foremost, the court does say in paragraph 75 that there are enough reasons to believe that the court can indicate the measures asked for by South Africa. So the court has found that there's plausible grounds, there are plausible reasons to get this interim request answered by the court. In paragraph 76, the court also went ahead to note that the court has the power to indicate the measures. It made references to its own statute and came to the decision that it is within its power to make these indications, and it went ahead to make the indications. In paragraph 77 of the judgment, the court said that its judgment, the issues indicated, the powers exercised on this occasion do not have to be exactly the things asked for by the applicant. So the court has had its own opportunity to hear the case and is indicating measures based on its collective appreciation of the case rather than just everything which South Africa has asked for. That's quite important to note. Courts are not slavish to whatever parties ask for at all times. So that's paragraph 77. In paragraph 78, the court indicated that Israel, and this is where it starts getting very serious for Israel, Israel must take all measures to prevent commission of all acts which are condemnable and have been legislated against in the Genocide Convention. So clearly, the court is saying that Israel has a duty Israel has a duty to take all measures, and that's not a simple thing. That's all measures which theoretically could include stopping the entire military operation. I'm not saying that's what Israel is going to do. I'm not even saying that's what Israel should do. But I am saying that the court is quite explicit on the possibility that even that can happen, because you can say it is within the all measures that Israel has to put in place to avoid getting against the Genocide Convention or acting against the Genocide Convention. And therefore, the things that Israel must stop according to paragraph 78 include killing members of the Palestinian group, the Palestinian community. Some will say the Palestinian state must stop serious bodily or mental harm being occasioned on them. C, Israel must stop deliberately inflicting on the group any conditions, any set of conditions of life calculated to bring about their physical destruction. That's just clear. And D, that Israel must stop imposing measures intended to bring about a situation where the Palestinian people can continue having babies and giving birth. That's the territory we are in. We're in the territory where there is suspicion that Israel is even doing the best it can to prevent births of a group. And the court is saying here that even that is something which Israel must take all necessary steps to stop. The court also went on to say in paragraph 79 that Israel must prevent and punish all persons who are inciting the Israeli state to acts of genocide, to all the acts mentioned above, preventing births, causing unnecessary and dangerous conditions of life, killing members of the group. Anyone who incites and encourages the commission of genocide, the judgment of the ICJ is that Israel must not only prevent that from happening, but must also punish it. So clearly we have a situation here that binds even the Prime Minister of Israel. And we know that the Prime Minister of Israel has been making statements which a lot of people might argue are genocidal in intent. And at the very least, we've had several members of his government. It's known to be a right-wing government, a coalition of the terribles. And they might have been saying things carelessly, which have been inciting troops. And even some members of the Israeli military have been alleged to have been doing this. So this judgment makes it clear from now on, from this afternoon, that anyone who makes such statements, the state of Israel is bound to react to that and to even punish. That's what the order of the court says in this interim measures of protection judgment. In paragraph 80, the judgment says that the Israeli state is bound to enable basic services to run in the Palestinian Gaza Strip. The court considers that Israel must take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance. This is another obligation that has been placed this afternoon and until this case is disposed of on the Israeli state. In paragraph 81, the court also went ahead to indicate something which I find a bit of an icing on the cake, and that is that Israel is bound to enable us find the evidence that genocide either has been committed or is being committed or will be committed. Israel must prevent the destruction of evidence. The court considers that Israel must take immediate and effective measures to enable the provision of preserving evidence relating to allegations of acts which go against Article 2 and Article 3 of the Genocide Convention. This is a beautiful judgment in so many ways, and it is to be celebrated. Further on, icing on the cake, the court says that Israel must make reports. Israel is now obliged to make reports to the ICJ itself on how it is progressing in giving effect to these provisional measures. So it's not enough for Israel to go off on its own and think that I go ahead and do whatever I want. They might say that. There's already indication that such satanic verses of thought is coming out from the government. But what people say in the political arena is quite different from what the legal obligations of a state are. And the legal obligation of on the Israeli state now is that it must give reports to the ICJ on the implementation of the provisional measures. Now let's go on, I would say, to some of the contextual issues, in relation to this judgment. And with that, perhaps I should introduce the ICJ to my audience again. The International Court of Justice is also known as the World Court. It's been existing since 1945. In my book on the law and practice of the International Court of Justice, 1945 to 1996, which is the period which my analysis covered, I took the view that the International Court of Justice is a very important court and that it satisfies 4 to 5 crucial functions in international relations. To begin with, it's a conflict resolver. The International Court of Justice is has been set up by the UN to resolve conflicts. So this case is certainly one in which conflicts have been resolved, or at least a conflict is being resolved, and we are even seeing orders emanating which help in maintaining international peace and international justice. A second function of the International Court of Justice, I note in this book, is that it offers a cooling off function. Precisely on issues like this, the court offers the international community an opportunity for level-headedness to reign. So rather than aggrieved states running off to join up with, say, Hamas and supplying Hamas with weapons and supplying Hamas with direct support, they have something legitimate to do. They have something which calms everybody down while we talk in court. And this is one of the things which the court has done on this occasion, a cooling off function, giving us time to get measured legal solutions. That cooling off function, some may say, takes too long because this case, for all intents and purposes, can still go on for years. And even that number of years spent in court is part of the cooling off function, in as much as we would wish that judgments of the International Court of Justice come faster. The court offers a diplomatic function. A diplomatic function is another of the roles and the functions of the International Court of Justice. And what do we mean by a diplomatic function? As it offers what I have called a cooling off function, so also does it offer things to happen on a diplomatic level. We have already seen how some states have, in a sense, taken sides with the major parties in this case. We've seen how some states have tried to join up with South Africa as friends of the court or co-applicants. We've also seen how the Federal Republic of Germany has joined up with Israel to present a case to present its their own side of the case in this matter before the court. The court offers the function of being an arbiter amongst nations, a guardian of international morality, and in a sense, a court has the role of advancing jurisprudence. What do we mean by advancing jurisprudence? This would be a good opportunity for us to see a judgment that comes out of this case, which helps us to understand better the duties upon states when they are dealing with the issues of war and peace, particularly in relation to prevention of genocide. So we are hoping that the law will be advanced here, that it will be fine-tuned, that we will have more armory we'll have more weapons in our armory in trying to prevent the worst aspects of international relations, particularly in relation to having bloody wars and wars where people die in high numbers. That's one thing that I think is quite important. So we've sorted that out. Those are the roles of the International Court of Justice. Now let's consider what's the value of an interim measure. What's the value of orders of interim measures given by the court? It can be very valuable. To indicate interim measures, the court must be satisfied that there is a substantial and imminent danger of steps being taken which might be prejudicial to the effectiveness of the ultimate decision on the merits. So this is what the court has done here. This is why the institution of interim measures of protection exist in the statute of the International Court of Justice as much as it exists in many international courts. So the interim measure of protection is a basic function of law courts, and it's a happy coincidence that it exists for us on this occasion, because otherwise, how else do we get Israel to know that it has to apply the brakes even as the case continues at the International Court of Justice? Now, that's me being happy about this decision and me being giving a good report of what the work of the International Court of Justice is. Now, how about me being critical of the International Court of Justice? This is something we also have to do. Some are disappointed. Some are saying what we needed from the court on this occasion, as at today, as at this minute, was an order from the court saying that Israel must stop its military actions, its bombing, and all military. There should be a cessation of hostilities. That's the ideal situation which a lot of people are waiting for. Well, we never get the ideal situation from any court. We certainly don't get it from the International Court of Justice. In fact, I am pleasantly surprised that the judgment of the court on this occasion has not been more sterile than it is. Judgments of the International Court of Justice can be disappointing, can come out as sterile on occasion, and sometimes can even be outright disappointing. And I'll give an example of that, which I wrote about in this book on the International Court of Justice, which is that in previous times, the International Court of Justice has given decisions that tend to look as if it sides with the colonial powers. It sides with the side of hegemony. It sides with the powerful structures in international relations. And I give example of a case which relates to the Southern African situation itself. South Africa has brought the case. We are happy about that. But that's only because South Africa is now a free, independent nation, free from apartheid, which is something which we cannot say the Palestinian people are even free from yet. Yet, at a time when two countries, Ethiopia, and I'm going back into the history of the court here, when Ethiopia and Liberia sued the apartheid state of South Africa in the early 60s, in what is known as the South West Africa cases, brought by Ethiopia and Liberia, the decision given by the International Court of Justice was very disappointing on that occasion. Why was it disappointing? The court came to the decision that both Ethiopia and Liberia, even though they are African states, have no local standing to bring a case against the South African apartheid state. And just like that, even after the court had gone through the preliminary stages like this, as we have gone through in this case, the court had said that there is a case to be had, and these are a set of interim measures that must be obeyed, and then the preliminary objections of South Africa were gotten rid of. The court took 6 years only to come to the decision that the complainants had no case because they didn't have local standing. Not that they didn't have a case that South Africa should have handed over and stop its apartheid policies and all that. No, that's not what the court said. The court simply came out with the decision that they had no case because they didn't have the local standard. They didn't have a right. They didn't have a business to be involved in this case. That was a very disappointing judgment, and I noted in my book that the fragile confidence in which these states, that's Liberia and Ethiopia, held in the court must be reciprocated with very careful decisions as to what the ICJ considers tenable legal arguments as opposed to historical, sentimental, or even religious considerations that may be given weight by the parties from the developing world, as in the Southwest Africa cases. I came to the conclusion, and I'm trying to summarize here, that the international law being developed by the court on the basis of shifting stances of its judges from Europe and North America has been observed by the developing states. This obviously has not inspired confidence in the court as a dynamic instrument of justice to maintain the right balance between stability and change, as well as between the rich and the poor. I am quite happy to say that the court has not been that disappointing on this occasion. Although the court has not ordered Israel to stop, well, the court has given Israel enough in its indication of the future to include the possibility of its stopping, especially because everything it does from now would bring into question its morality as a state, as well as its duty to pay reparations and to exhibit what we call international responsibility. And this is where I want to come to Malcom Shaw's book. Malcom Shaw is the lawyer handling this case for the State of Israel. Malcom Shaw is a fellow academic and actually an acquaintance of mine, at least academically. We exchange emails. We've exchanged emails in the past, and might I also add to this that Malcom Shaw was one of the counsel that handled the case for Cameroon, in the case between Nigeria and Cameroon, known as the Land and Maritime Dispute between Nigeria and Cameroon case, a case that was disposed of in 2002 by the International Court of Justice. So he's an old hand at this, and in a sense an authority in international law. And I want him to take some messages home to his clients because he is a respected figure in this area, and I would want to direct him to his own writings. I want to direct him to his book, International Law, the 4th edition, pages 185 and a few other pages which I will be talking to. From now on, it gets serious for Israel. From now on, there is international criminal responsibility for the Israeli state's action. And that international criminal responsibility attaches not just to the State of Israel, but to individuals in the State of Israel. So I refer Malcom Shaw to communicate to his clients that since the Nuremberg Charter, we now have a situation that the General Assembly in 1946 and the principles of the Charter and the decision of that tribunal make it clear that there is international responsibility for people who commit acts of genocide, people who encourage acts of genocide. And Malcom Shaw wrote, and I quote here, that the responsibility for genocide has been reaffirmed in the Genocide Convention of 1948, while the International Convention on the Suppression and Punishment of the Crime of Apartheid of 1973 declares apartheid to be an international crime involving direct individual criminal liability. Malcom Shaw needs to pass on the message to his clients very quickly, for their own sake, for our sake as the international community, for the sake of what I would call the international rule of law. And I will also want to direct Malcom Shaw's attention to chapter 14 of his book, where he talks about state responsibility. The state responsibility of Israel is now clear. With these provisional measures, we now know that any action taken by Israel in ignoring these provisional measures and ignoring the general field of international law and its obligations under international law will create state responsibility on that state. State responsibility, and I quote Malcom Shaw here, state responsibility is a fundamental principle of international law arising out of the nature of the international legal system and the doctrines of state sovereignty and equality of states. It provides that whenever one state commits an internationally unlawful act against another state or people, international responsibility is established between the two. A breach of an international obligation gives rise to a requirement for reparation. Malcom Shaw, KC, King's Counsel, please take this message home clearly to your clients. Please advise them that Article 1 of the International Law Commission's draft articles on state responsibility reiterates the general rule that every internationally wrongful act of a state entails responsibility. Article 2 emphasizes that every state is subject to the possibility of being held to have committed an internationally wrongful act entailing its international responsibility. These basic reaffirmations on the foundation of state responsibility are reinforced by two further principles or further articles. Article 3 and Article 3, for instance, provides that an internationally wrongful act by a state occurs when a state conducts itself in an act of omission or commission that is attributable to the state under international law, or B, that such a conduct constitutes a breach of an international obligation of the state. I take my time to explain these issues in this way because it needs to be clear to those who are handling the legality of Israelis' actions, both their military lawyers, their government lawyers, and anyone who is assisting them, including those states and statesmen that line up behind them, that there are acts of liability that are imputable, that there's imputability of responsibility for this damage on them individually as well as on their states. So this judgment sends messages, sends a clear legal situation. There's clarity upon the fact that there are obligations on the state of Israel. There are obligations on individuals that support them, as well as imputability of responsibility, absolute liability on anyone who assists them. I quote Malcom Shaw for a last time: imposing upon the state absolute liability whenever an official is involved that encourages that state to exercise greater control over its various departments and representatives. See page 547 of Malcom Shaw's work, International Law. The general principles of international law are opposed to most of the actions that Israel has taken since the beginning of its actions over the territory of Gaza. Indeed, it is a shame that Israel comes to the International Court of Justice knowing fully well that it has ignored several other judgments by international courts, including the International Court of Justice itself, that it ignored even the legal consequences for the building of the wall advisory opinion given by the International Court of Justice. Israel weeps and cries publicly every time it is told to do anything international law or under international law, stating and alleging that the international legal system is against its interest, that the UN has been hijacked against its interest. We would like to remind Israel that Israel itself would not have existed if not for international law and if not for the United Nations and its ability to maintain an international rule of law. This is an opportunity for the state of Israel to make a U-turn and to become a decent state and not to evolve into what appears to be a little nasty contraption rather than a state. Thank you for listening to me on this, and we meet next time.